Good morning, class.
Good morning, sir.
Good morning.
Good morning, sir.
Yeah,
Good morning, sir.
Good morning, sir.
yeah. I want to believe you guys are doing well.
Yes, sir.
At least I can
Yes, sir.
sense that in your voices. All right, so my apologies for coming in a bit late. Needed to attend to some matters of the states. All right, so we will take it up from where we stopped in our last class. And by my understanding, we are to start with topic 4, which is interpretation of statutes. Interpretation of statutes. And that's the topic number 4 for this level. And by the time we are done with this particular topic, we will have been able to have a good grasp of what the topic is all about. And we would have looked at the various rules of interpretation, which includes literal rule of interpretation, the golden rule of interpretation, the mischief rule, and so on.
I can't hear you. Sir. Guys, the class is full. I don't think the host will invite me.
The lecturer is out again. They look for somebody that will leave. I don't want to leave.
You leave. What happened to your own
Only
hand?
the fireflies people should remove their.
Leave.
Hey, Abiu.
Leave care.
Leave.
All right, sorry. Can you hear me now?
Yes,
Yes,
sir.
Yes, sir.
So sorry, there was
Yes.
a power outage here, so it affected
because this is
the internet connectivity, but I'm back now. And the powers that are behind the power outage will no longer be able to take it off again. All right. So let's look at the topic statutory interpretation. And let's take a look into the introduction to the topic. Now, the process of lawmaking, otherwise known as legislative process, which we have discussed in this class, is such a process that requires time. Apart from time, it requires resources and also both human and material are expended in the process of enacting laws, or simply put, of making law. And the legislature will consider all parts of the process, some that are even classified as loopholes. And at every point in time in the process of the lawmaking, they make efforts to correct errors, to correct omissions, and to fine-tune areas of the process that require clarification in order to ensure that they bring into being law that is without any form of ambiguity. But when you look at the nature of man, you discover that man in itself is not perfect. So despite all the effort that may have been deployed in the process of lawmaking, we still discover that errors are unavoidable. And sometimes even usage of words may be an issue. Usage of a particular term that may mean something to a lawyer may mean a different thing to a mass communicator. It may also mean a different thing to an accountant. That was why when a friend was sharing with us recently, when he went for his PhD defense. Hello, Adeyemi, you're raising your hands.
Good afternoon, sir. Sir, is this lecture for year one?
Yes, please.
Okay,
It's
sir.
part of, yeah, like I said, I understand that ICE and mass comm 100 level are with us. You offer this course as your 100 level course. Why the 200 is one of the courses for the 200 level law students. So this is just like I told you when we started, except maybe you joined their class very late, that this is just for you to have this lecture ahead of your own time, because you are still going to take this topic before the end of this semester. I'm sure 99% of your course mates are aware of that. So all you just need to do is to follow the course outline that we are dealing with. All right, so I continue. Balogun, yes?
Sir, please, is the course also for LIS today? The topic, I mean.
Do we have
is
LIS taking introduction to law?
Yes, sir.
no.
Okay, all right. Well, yes, it's for
Yes,
you,
sir.
but we are not aware that you have joined us. So reach out to either Oluwole or Isaac of mass communication, or you reach out to me immediately after this class so that we know that your department is now part of the process. Okay? But it's still, the course is still for you. So I will address you when we have our own separate class. I think later today or on Friday. All right, so
Okay, sir.
if you have any other question relating to that, please you can speak to your coordinator, then pass it across to me later on. We will address it while so that we'll be able to maintain the sanity of this class. All right. So, like I said earlier, irrespective of the level of carefulness that may have been deployed by the lawmakers, sometimes words that are used in the formation of laws may become difficult for others to understand, or it may mean different things to different people. For instance, like I was saying before the questions came, a word, for example, I was sharing with you that if a colleague of mine went for his PhD defense, and in the course of the PhD defense, there was a particular word that was peculiar to the subject that was being discussed, which is in law, we say admissibility of evidence. Just take that word. We don't need to bother so much about what it means. So when he was having his PhD defense, the panel is usually made up of experts from either history, from philosophy, from English, mass communication, all across board. And then he was sharing with us that it got to a point that one of the panelists was objecting to the continuous use of admissibility, that the word admissibility was featuring too often in the entire work. So, of course, that word cannot be replaced with any other word as far as law is concerned, especially when it comes to issue of evidence before the court. So, but because the people that were listening were not lawyers, they feel that why don't you look for another word that's suitable to describe what you are trying to explain. So that is how our world can become complex to the extent that people may not be able to understand it. So, despite whatever carefulness that may have been deployed in the process of lawmaking, there will still be some form of ambiguities, some form of words that are not clear, that are not, properly understood. Let me put it that way. And then some of these words, because they are legal terms, they do not oftentimes have a substitute. So what happens therefore is that when such laws are to be interpreted, it will end up that people tend to attribute different meanings to it. And sometimes the meaning of the word, they are muddled up. And then there is need for clarification to be done. And that is the essence of this topic that we are looking at today, which is known as statutory interpretation. Okay? So it is the judiciary who is saddled with the responsibility of interpreting the laws. So if the judiciary is saddled with that responsibility, how then is the judiciary expected to provide adequate interpretation to whatever statute or law is in question? Now, let me take you further this way. In English law and within our own jurisprudence, the principal source of legal rules are statutes and precedents, that is case law. And by now, I'm sure that case law or precedent is not new to anybody in this class, be it, those of our students who are joining or are just taking the lecture ahead of their normal time. We understand that the principal sources of legal rules are statutes, laws that were made. And that was why when we're looking at the sources of Nigerian law, we did refer to Nigerian legislation, we refer to received English law. Under the received English law, we talked about the doctrines of equity as part of received English law. We talked about common law. We even talk about Islamic law as an independent source of Nigerian law. So also, we spoke about customary law. Now, yes, all of those constitute sources for every law. But yet, even though those laws exist, the duty they have is to be simple enough to be understood. And irrespective of how they were formed, whether maybe through case law, through the usual process of lawmaking, they are expected to be able to fulfill the purpose of their formation. So, generally, laws or statutes, which we can also generally refer to as law for the purpose of this class, usually come in a clear set of words. So, but the principle of parliamentary drafting is certainty, meaning that when the parliament is embarking on the process of lawmaking, one of the things they want to achieve is that they are able to bring laws into existence with certain and specific meanings. Meaning that from the face of it, one should be able to understand what the law is talking about. I'm trying to share an example with you, just a provision of the law, and then you will, begin to have understanding of what we are trying to say. That when a law is made, it is supposed to be free of every form of ambiguity. And then it should be clear, the words should be clear, and every other person that is in interaction with it should be able to have clear understanding of what the law is saying. Now, This is an example of the law in Nigeria. I refer you to Section 44 of the High Court Law of Lagos State of 1978, for example. This Section 44 simply provides, and I quote, it said, customary law will be applicable in the court if it is not, one, repugnant to natural justice, equity, and good conscience. It is not contrary to public policy and or incompatible directly or by implication with any law for the time in force. That is a provision of a particular rule or law. Now, this law as contained here, it's supposed to be simple enough. Of course, it's simple enough for everyone to understand. And that is the purpose of judicial, that is the purpose of, one of the purposes that Parliament wants to achieve, clarity. But after all, law also ought to be certain. There should be no reason why a law should not be clear at all. In the Supreme Court, speaking in the case of Awolowo and Shagari, lay down the following principles for interpretation of statutes. That is, when there is need for the court to perform the function of interpretation, statutory interpretations, the court is expected to follow this principle as laid down in the case of Awolowo versus Shagari. The court said, and I quote, it said, a statute should always be looked at as a whole word used in a statute. The whole word used in a statute are to be read according to their popular meaning. That is, their simple meaning as they appear, so that they can be properly understood and deployed or used when there is need. Because a particular law is not expected to alter a particular law, existing law, except if the purpose of setting up the law is to amend that particular law. So what the court was saying in the case of Awolowo and Shagari is that any word that is used in formation of law should be interpreted based on its ordinary meaning. That is, there is no need to impute extraneous meaning into the provisions of the law as it may be stated, on the face of the document. So, meaning that ordinarily, the court is expected to deploy the ordinary meaning of every word. But you will see in the course of this class that sometimes if the court should strictly deploy the meaning as it appears in the law, it may also bring about injustice. And that's why there is need for the judiciary to deploy the different rules of interpretation, just for the purposes of those who may not be so familiar with where we are or this particular course before now. I want to say that by virtue of the principle of separation of powers, which was ordained by our Constitution, lawmaking function is vested in the legislature, while the function of the court is to interpret and apply the law. And the power of the court to interpret statute or law is a constitutional right that is vested in the court by Section 6 of the Constitution of the Federal Republic of Nigeria. You will see there that the judicial power of the Federation is vested in the judiciary. And what does that mean? It means that the judiciary, as an arm of government, has the duty to interpret and apply the law. So, what it means, therefore, is that, please, if you are not speaking to us, kindly mute your mic. There are about 5 people whose mic are not muted and are disturbing this class. Please mute your mics. Thank you. So, and again, the primary duty of the court is to arrive at the true intention of the legislature based on the letters of the statute, which are merely the external manifestation of the intention of the lawmaker. What we are saying here is that if the judiciary is to interpret a particular law, that the judiciary is duty bound to arrive at the true intention of the legislature. That is, what was the reason behind the mind of the legislature when that particular law was enacted? So, meaning that the privilege that the court has does not offer the court to rewrite state laws. They are only duty bound to interpret and apply the law. So, but yet the court of law will still go out of their way to ensure that justice is done. So, irrespective of how careful the legislators were when they were making the laws and how they scrutinized the process, there is still possibility of them making mistake in the course of discharging their duty. But what we are saying is that when the court is, however, called upon to interpret the law, the court, first of all, must put in mind the intention of the legislature when they were passing that law. I'll give you an example. There was a time in this country, not so far away from this time, that kidnapping was very rampant. And then it got to a point that people could no longer live free life because of the fear of being kidnapped. And one of the things the legislature did as at that time was to revisit the law on kidnapping and possibly to look for a way to improve it, either by increasing the punishment that is attached to it. And then the legislature went on board and increased the penalty that is ordinarily meant for kidnapping. What was the purpose? The purpose or the intention of the judiciary or of the legislature, sorry to say, as at that time, was to see how kidnapping can be reduced to the barest minimum. So when we are talking about intention of the legislature, we are talking about the reason for the law they are making at a particular time. So the intention basically was, if the punishment for kidnapping is made to be severe, that people will desist from committing the crime. Like I usually say in my class, maybe when I have opportunities like this, especially when I'm teaching, I usually say that the reason why some of us are not criminals today is because we are afraid that the law will catch up with us. Oh, that it is a law in Nigeria that if you commit an offense, you will be arrested. Upon your arrest, you will be taken to the police station and you eventually land in court, and the court will go through the usual judicial process to determine whether or not you are guilty. And if by chance the individual is found guilty, the individual is given a punishment to serve, either terms of imprisonment or fine or community service, as the case may be. Some, in the era of social media that we are in now, their own punishment that they consider as punishment is when they show their faces on screen, it becomes a permanent record in the world. He said, don't let them arrest you so that they will not show your face on Crime Fighter. Maybe that's the place I should have started from. That the reason why people run away from committing crime is so that they will not show their faces on Crime Fighter as criminals. So, of course, if people run away from crime because of that, the society is better for it. So taking your mind back to how the judiciary, how the legislature tried to increase the punishment for kidnapping, it actually probably made some people to stay away. So the intention of the legislature by reviewing that law is to ensure that as many as possible stay away from committing the crime of kidnapping. What we are now saying as it relates to the topic of discourse this morning is that when the judiciary is to interpret laws, the judiciary must put in focus the intention of the legislature that made the law, so that in interpretation, they are able to arrive or they are able to do justice rather than injustice. And that's why we said earlier that the power of the court to interpret laws does not extend to the court rewriting the law. Even though in the process of interpreting the laws, we later develop what we have case law. But the initial plan or function is for the court to interpret. But of course, when the court carries out that function of interpretation, it eventually becomes a case law which can guide the society in subsequent cases when it is to be applied in the same court or a lower court. So basically, the judiciary in interpreting the law must not tamper with the law. It must not impose its own meaning or its own conceived version of what the intention of the legislature was. What the judiciary is expected to do is that it should ordinarily concern itself with the alteration of words in a statute merely to make it read the way it thinks. So, if the judiciary feels that this is the intention of the legislature when this law was being made, all the judiciary seeks to do is that they must interpret the law to meet the intention of the lawmaker. So, in interpreting laws made by the legislature, the court is not even permitted to invite the lawmaker to explain what the provision of the law means. Meaning that the judge must find the intention of the lawmaker through the medium of the words used in making that law. But however, it is not always a very easy task to do, to ascertain the intention of the lawmaker from the words used. For those of us that were practically active during the just concluded election that brought in President Bola Ahmed Tinubu to power, there was the issue as to what amounts to whether anybody that wants to become president must win at the FCT. There was issues like that. Of course, it went to court, and the court gave a particular interpretation to it one way or the other. It was the contention of Alhaji Atiku Abubakar and Peter Obi that if an individual is to become the president of this country, by virtue of the law, he must win a majority of the vote cast in the FCT. But the court, in his own wisdom, provided an interpretation which the court believed was the intention of the lawmaker. But what we are saying is that if the judiciary wants to interpret, it must put into consideration the intention. How does the judiciary come about that? The judiciary can only come about that by looking into the words used. But we are also saying that that is not an easy task to do, because words sometimes are not easily ascertainable because they may not bring a precise meaning. Sometimes a law can be as long as about 5 lines, making up of phrases, clauses, and sometimes the clauses or the phrases may not be properly understood. Another angle to it is that there is no doubt that some of the words used in our laws can bear 2 or more meanings. So therefore, it may be difficult for the judiciary to find the exact meaning that was intended by the particular context in which the word was used. And it's even possible that the legislature may even choose a wrong word by the, when they were drafting. For example, the word or, which bears a disjunctive meaning. That is, it's lacking connection or consistency. As many, in many cases, being used erroneously. When you say and or, does it mean that when you take what is before the and, you add it to what is after the and? But sometimes it may mean that is it that once you take the first meaning, you don't have any business with the second part of it. These are issues that we are trying to address here when we talk about statutory interpretation. So the word or and may be what is causing a change in the law that has been presented. Sometimes the lawmakers may use wrong punctuation marks. And mind you, in English language, punctuation marks play vital roles in understanding what has been put forward. There are sometimes when you remove comma from a word, it means a different thing when you read it together with what is after the comma. So these are issues that may come up with interpretation of statute. Sometimes the legislature may impute unnecessary punctuation marks that is capable of creating a different meaning altogether in the word. So all of these are issues that forms the reason behind the discussion on statutory interpretation. So what this means is that there may be gaps in a particular law. And some authority contends that the courts are not entitled to fill those gaps in the laws. So when there are gaps in a particular statute, it is only the legislature that can, in the process of amending their laws, correct the lacunas or the gaps that may have been created simply because they are the one vested with the constitutional powers to make the law. So, therefore, if all that we are saying is making some sense, it therefore means that there may be laws that are capable of creating absurdity, creating unclearness. Therefore, what is then expected is that when situations like this occur, because they are all human, they are classified as human error. And it is not allowed for the draftsman, that is the legislature, to come to court to explain, like I said before. Then sometimes, even the words used today may begin to lose their meaning in the future. And because sometimes the legislature does not have the ability to foresee and provide for all future events and circumstances that may arise in relation to a particular subject matter that is being legislated upon. So, meaning that at one point in time, law may become inadequate when it is to be applied. Now, I give you an example here. In the case of Awolowo and Shagari that I mentioned earlier, the question that was before the court was the meaning of 2/3 of 19 states. How do you determine 2/3 of 19 states? It's difficult because 19 is not an even number. When the legislature were trying to determine how a winner can be determined in an election, they never envisaged that 2/3 may become an issue for interpretation. If they had foreseen that problem, they would have been able to either change what they said, what they meant as law, and then to avoid any form of ambiguity or unclarity in the process of lawmaking. So, what we're saying, therefore, in the light of all of this, is that there may be needs for statutory interpretation at all times. And then the court is the one that is saddled with this duty. And in doing so, they must follow the available rules in interpreting the law in order to come up with the intention of the lawmakers that made the law at that particular time. And that's why the Supreme Court, in that case of Awolowo and Shagari, it's online. You can Google it if you want, if you are interested in reading it. You can Google Awolowo and Shagari and probably tell Google to tell you, what transpired in the case, do a summary for you, especially as it relates to issue of two-thirds majority and all of that. Now, the Supreme Court said in that case, as it relates to issue of ambiguity, especially the two-thirds of 19 states that we mentioned. This is what the Supreme Court said, and I quote. The Supreme Court said, in most countries with common law jurisdictions, such as Nigeria, it is generally accepted that it is a function of the judiciary to interpret the law with the minimum of direction from legislature as to how they should set about this task. Thus, nearly all the principles, precepts, and maxims of statutory interpretation are judge-made, meaning that, yet, even though the court may find it difficult to perform this duty, but the court must look for a way to go about how they can arrive at doing justice when interpreting the law. So, in that case also, the court also observed that the three major rules of statutory interpretation, or what we refer to as main canons of interpretation of statutes, are referred to as common law rules. So, the rules that we're going to be talking about here that helps the court to interpret appropriately, they are referred to as common law rules. Mind you, what we call statutory interpretation can also mean canons of interpretation, that is, the rules of interpretation. So there are three rules which I'm going to list now. The first one is the literal rule of interpretation. The literal rule of interpretation. The second one is the golden rule of interpretation, while the third is the mischief rule. So, these are the three major rules of interpretation of statutes that we are going to look at by the time we meet again in our next class, because our time is almost up, and I know that other students may have some other courses after now. But what we are saying is that there are what is known as common law rules of interpretation, which the court have adopted over time in order to be able to do or carry out the function relating to statutory interpretation. Mind you, just to simplify it, statutes can also mean law. So when we're talking about statutory interpretation, we are talking about law, interpretation of law, or interpretation of rules, or interpretation of regulations, as the case may be. But for the purpose of this class, and to wrap up the introduction we have done into this main topic, we are saying that there are 3 canons or rules of interpretation, which involves literal rule, golden rule, and mischief rule. So we are going to take them one after the other and deal with them on their own merits in order to see how they affect interpretation of law or statutes. So before we call it a day, I don't know if anybody has a question on this general introduction that we have done into this topic so that we can use the little time we have left to address it. So the floor is open. If you have a question, feel free to ask. If we can answer you, we answer. If we cannot, we'll look for a way around it. Yes, any question? Chantel, yes, go ahead.
Good afternoon, sir.
Good afternoon.
So when you were given the, I think, definition of the statutory interpretation, I didn't hear what you said about the definition.
Definition of what?
Statutory interpretation. You said the process of lawmaking, otherwise known as the legislative, is a process that's all I got.
Well, I may not remember exactly what I said, but I was just talking about the fact that I was laying a foundation to interpretation of statute, that before there can be interpretation of statute, laws must have been made. And I said in the process of lawmaking, usually the legislature may commit some errors, and that is what usually leads to interpretation of statutes, or what we call statutory interpretation. That is interpretation of law, simply put. Is that okay? Collins, let me,
Yes,
yeah,
thank you.
before you ask your question, I have a question for this class. I would like this class to mention the importance of statutory interpretation, at least 5. Let me take the question of Collins before we take that quickly, and then we wrap up.
Okay, sir. When you were explaining, you talked about the fact that when the court is trying to interpret the statutes, it's not allowed to call on the legislature. But I want you to understand the rationale behind that, because it will make the job of the court way easier to
Okay,
interpret.
you want me to
statutes.
understand the rationale behind it, or you want to teach us the rationale behind it?
I want to know, sir.
You want to teach me the rationale behind it, or no?
No,
Feel free.
no. I want you to tell me, as well as the class, the rationale behind that.
Okay, the rationale behind not the court having power to invite the legislature to come and explain.
Exactly. Because
All right.
calling on the legislature or like the draftsman to come and explain will make the job of the court way easier.
Yes, it will. Then it will also make the work of the legislature very cumbersome. Meaning that the High Courts of Badagry, Court 1, may be calling on the judiciary to come and interpret may be calling on the legislature to come and interpret a particular provision, while the High Court of Okigwe in Anambra State, yes, is asking the legislature to do the same, as well as the High Court of Borno State. Then how will the the legislature, be able to perform their normal function? It will become difficult. And that is the rationale. Well, that's one of the rationale behind it. Because sometimes even the legislatures, those who were in that parliament, when the laws were made, majority of them must have died. So where do you get them back? Do you apply to God to release them, to come and explain to the court? There are issues of impossibilities that comes with it. Okay? I hope I was able to answer your question to some extent.
Yes, sir. Thank you, sir.
All right, so to my question, what are the importance of statutory interpretation? Anybody? Importance of statutory interpretation. Yes.
To find out the meaning of ambiguous words or provisions in the statutes.
Okay, that may be it. Yes. Next.
To ensure that there is predictability and consistency in the interpretation of statutes.
Your Igbo is too big. What did you say first?
I said that to ensure that there is like predictability and consistency in the interpretation of.
All right. Okay. Yes, that's a good one. Yes.
Lay solid ground for the case law.
Yes.
To clarify legislative intent, sir.
Okay, that's beautiful. Yes.
Sir, to make the law simple and clear to understand.
To make the law simple, yes.
To avoid
the societal changes so that they remain like relevant and applicable.
Okay. All right. Yes, I also agree. Yes.
To avoid the alteration of already laid down.
To avoid what?
The alteration of already laid down rules by trying to interpret the laws. So the reason why statutory interpretation is necessary so that to ensure that the intention of the legislature is put first.
Okay.
In interpreting the law.
All right. Thank you.
To lay solid ground for the lower courts as regards case law.
I didn't get that. Olu Yinka.
To lay solid ground for the lower courts as regards case laws.
All right. That's very beautiful. Yes.
Inability of lawmakers to anticipate possible situations and pass relevant law to cover same.
What?
Inability of lawmakers to anticipate all possible situations.
Beautiful, beautiful. I think I'm satisfied that. Thank you very much. Let's stop there. I know you have beautiful answers, but from the answers I've gotten, I'm satisfied that we've been able to do justice to the introduction to this particular topic. All right, so it's a convenient time to call it a day. I enjoy you to please start reading your books, consult your textbooks. If you have to listen to these lectures again, please do so that you will be able to do well during your examination. Like I said before, nobody, I repeat, nobody is permitted to fail this course. Thank you for listening and enjoy the rest of the day. Bye.
Thanks, sir. Bye-bye,
Thank you, sir.
Thank you, sir.
Attendance.
Thank you, sir.
Please attendance.